Good afternoon, everyone, and welcome again to today's edition of The Law and You. I'm your host, yours truly, Shellon Washington, attorney licensed in the state of New York, in the country of Guyana, and Trinidad. And today, guys, we're going to be speaking about asset division or equitable division of assets during a contested divorce. And for those of you who don't know, and you might be asking, what is a contested divorce? A contested divorce is one in which one party or both parties wants to be divorced from each other, but they cannot agree on the terms of that divorce, either because one party believe they're entitled to more assets than the other, or one party might just flat out believe that the assets is theirs and the other party was just there for, I don't know, whatever reason people choose to be in a marriage. As you know, a marriage is not always what it seems like on the outside. A lot of times people marry for convenience. It could be an arranged marriage. It could be different reasons. It could be one for economic gain, financial gain. But do understand that people do get married for different reasons. And once that marriage comes to an end, the parties just simply have to decide how is it they're going to part ways on their assets. How is the assets going to be distributed? In some instances, there are no assets to be distributed, which makes it very easy for one party or for both parties to just go their separate ways. But in instances where there's actually assets, and those assets don't necessarily has to be a house, a car. It doesn't have to be something that's tangible in that nature. It can be like a retirement account, a 401k, a pension, deferred compensation, an investment account, a bank account. It could be all those things that the parties has to figure out what and how they're going to divide their assets. So today I'm going to try to break it down for you, how those assets are going to be divided during a contested divorce proceeding. A lot of times people, they think about the divorce, but they do not contemplate the fact of how the assets could be distributed. And those of you who haven't seen my previous videos on prenuptial or postnuptials, you should go back and look at those videos, because those videos are also helpful to prevent a situation where you end up in a contested divorce. Please note that most of the times when a divorce becomes contested, it has nothing to do with the grounds, hardly unlikely. I mean, there are instances where one party is very, very hurt, and the party who's really hurt, they cannot stand the fact that one party might have blindsided them with cheating, infidelity, basically, and they become hurt and they want the grounds for divorce to be adultery. But please note, in several states in the United States, several of them have a no-fault divorce, meaning that you don't have to have a reason. You could just not like someone anymore and decide, okay, I'm going to divorce that person. And as you know, you have seen this on TV with celebrities. Very often celebrities marry and then you see them divorcing within a week, a month, a year later. And those things happens because those celebrities ensure that their assets are adequately protected by virtue of a pre or post nuptials, so that when they do decide to part ways, it's very easy. There's no contest. There's no fighting. And a lot of times people marry down. They take somebody of a less financial status, because as you know, the world, as based on financial reports, there's just basically 1% who is really, really wealthy. And then you have the other upper middle class, and then you have the middle class, and then you have the working class. So a lot of the times people have to marry someone who is not really on their economic status. And when that happens, you need to secure yourself by either getting a prior to marriage, getting a prenuptial, or if you do get married Before, if you just married a person without protecting your assets, you have to sit down and have a conversation with that person to see whether or not that person would agree to having a post-nuptial executed between you and them. If the party does not want, if the spouse or the person you married does not want to have a post-nuptial, then, or you don't have a prenuptial, then you are likely to end up in a contested divorce. Now, let's dissect the contested divorce a little bit in terms of the assets. What assets are considered marital assets? Because as you know, if the divorce becomes contested, one of the first things the court is going to want to know, or you yourself going to have to determine, is what is marital assets. Now, marital asset could be any asset that the parties acquired during the marriage. It could be from your source of employment income, or it could be from the source of investment. In some instances, some people could win the lottery. And if you win the lottery during the marriage, guess what? That lottery ticket is marital assets. There are instances where people won the lottery and then they attempt to divorce the spouse without letting the spouse know that, hey, I just won the lottery, because they didn't intend to share the proceeds of that win with the spouse. And then later on, the spouse finds out and bring a claim against that spouse for their amount, their equitable distribution in terms of that lottery win. Now, if you decide that you're going to engage in a contested divorce, you have to determine what assets you own are considered marital, and whatever assets your spouse own will be considered marital assets. Now, like I said earlier, marital asset is any asset that the parties acquire during the marriage. Now, it could be from a business. Some people start a business during the marriage, and that's considered marital asset. Now, it could be a situation where you started the business before you get married, and therefore, after you get married, the business is continued to gain assets, and it's continued to do very well. And that business is considered marital asset, whatever portion of it the asset is earned during the marriage. Now, if, for instance, you do not work in the business, but you hired people to work in the business is self-sustaining, and you have nothing to do with it, so that there's going to be no commingling of marital and non-marital assets, then the business could remain separate and distinct from marital assets. In some instances, a party might enter into a marriage with asset that they had before. They might have owned an house before, a car before getting married to their spouse. And if you owned anything before you get married to your spouse, you can maintain the independence of those assets and keep those assets as non-marital assets. But how do you keep assets from being commingled with marital assets? It's simple. You just do not take anything that you earned during the marriage and invest it into those assets. So, for instance, if you own a house and the house has tenants in it, you allow the income from the tenants to pay for those properties. And you do not, under any circumstances, go and use your own money from, let's say you have a W-2 job, and invest into the house. So, for instance, if the house needs a roof, do not take your income that you're working for during your marriage and invest it to fix the roof. Take an equity loan instead and fix the roof, or do a mechanic lien on the property and fix the roof. Or you can also use any money that you would have saved up from collecting the rental income from the tenants to fix the roof. But do not, under any circumstances, go and tell your spouse that the roof on this property that I own prior to marrying you needs fixing, and I believe we should take the money that we have jointly in our bank account and fix the roof of that property. Because if you do, then a portion of that property then becomes marital assets, because you used marital funds to invest into that asset. Also, similarly with your retirement accounts, the same thing goes. If you have a retirement account and you want to maintain the distinctness of that retirement account. Let's say you started that job in 2007 and you got married in 2022. Now, the entire portion from 2007 up to the date you got married is considered non-marital asset. And then from the time you got married, moving forward, everything after that is considered marital asset in that retirement account. And then when you do become divorced or you do intend to file a divorce complaint, the date of filing of that complaint is considered the cutoff date to which your spouse will be able to get your retirement account. And I think it's really important that people understand these facts. People must understand these factors because a lot of times people separate from their spouse, they go live their separate lives, and they remain married for whatever crazy reason. They keep the union between them and the spouse. And it makes absolutely no sense unless you have a separation agreement in place. There is absolutely no reason for you to remain married while you and your spouse live your life apart from each other. I know sometimes people do it for the benefit. A lot of times, based on the laws in the state, because in the state of New York and in New Jersey, once you're divorced, you're not entitled to your spouse's health benefits or anything of that nature. You lose the dental, the vision, the medical, you're going to lose it. So if you're on your spouse's benefits, I would suggest you go get your own through your own job or otherwise purchasing on an open market. Because once you get that divorce, the law says that you're no longer entitled to use those benefits. And I think a lot of times it makes perfectly good sense to ensure that you put things in order, because if you don't, and you remain married to that person, the person with the right to do anything on your behalf if something were to happen to you is your closest next to kin. So that will be your spouse. And there's a situation that I'm aware of where a person who separated from his wife many, many years ago, but for whatever reason, he decided he was never going to file a divorce from his wife. So he and her remained married while she lived with another man and while he moved on with his life in different relationships, many different relationships. So what happened? He got sick. He got really sick and ended up in the hospital. When he ended up in the hospital, he ended up unconscious so that he was unable to make any decisions on his own. Guess who they called or who showed up? Exactly. His wife showed up because she was legally still married to him. And she began to make decisions for him, which I'm pretty sure he would have never made had he had the opportunity to do those things himself, or if his children had the right to make those decisions for him. But the devil herself showed up at his bedside while he was in the hospital and made decisions for him as regarding his medical treatment, regarding his discharge or stay in a hospital or in a nursing home. She made all those decisions for him. And when it was quite clear that those are probably not the best decision in his situation, and his children probably would not have made those decisions, they would have made better choices, because obviously their goal would have been to prolong the life of their father. Anyway, I'm telling you guys this to make sure you understand how important it is to protect yourself and protect your assets if you decide that you wanted to divorce from your spouse or you wanted to go your separate ways. Do not let it linger without either having an agreement in place or go file that divorce. Don't wait till next year or wait 10 years down the line or 50 years down the line. Another reason why it's also important to make sure you put these things in place is the simple fact that a lot of times people get abandoned in relationships. And I know a situation with a client, the husband picked up, moved out of the house, left her there. She was working, but her income was insufficient to provide and continue to pay the rent. Rather than her going and ask for maintenance before the family court, what she did, she stayed there and she continued to pay the rent on her own. When she began to struggle, she decided to pick the phone up and call me. But this was like 4 years later. Now, if you decide to do this 4 years later, chances are you will never succeed in getting any type of support, because the whole 4 years, how were you supporting yourself, right? You had to have been either self-supporting or you had a different means of being supported. So the court, in order to grant any person or any spouse any type of any type of financial support, maintenance, the court has to look to determine whether or not the spouse is self supporting. And the court is also going to look at what the lifestyle of the parties were before the divorce was filed, because the purpose of the spousal support is to maintain, help you to maintain your same lifestyle, your status quo, and to be, self-supporting. So that extra income coming from your spouse is going to assist you in order to support yourself and avoid becoming a ward to the state. So the state may never have to give you public assistance, right? But you would think people understand this, and therefore if the spouse walks through the door, the first thing they're going to do is pick the phone up and call me or call a divorce attorney, or even go to the family court and ask to file a petition for maintenance. But a lot of people do not know this information. So what they do, the spouse walks out, they can't pay the rent, they stop paying the rent or the mortgage, and they will struggle, borrow money from friends, family, whoever, and then 10, 20 years down the line realize that they needed support because the spouse is doing well, he is working, he has a steady income, and then they believe somehow that the court is going to be willing to award them some sort of maintenance after all that gap, though so many years has passed and they've been self-supporting. Doesn't work like that. The way it works is that the law wants to make you self-supporting, or it wants to ensure that based on your own income and some income coming from your spouse, you'll be able to stand on your own feet. Also, bear in mind, it depends on the length of the marriage. So the longer the marriage, the greater the reward. The longer the marriage, the most likely it is that you'll be awarded a decent amount to support yourself or to assist in supporting you while you continue with your life. Another common mistake with that is that sometimes people go, I've said it before on a different show, they go, they marry, they bring somebody from their home country, and they're expecting that if the marriage doesn't work out, I'll be able to throw the person out in the street and I will not need to support that person. But it doesn't work like that either. If you take somebody who has never worked a day in their lives and you bring them to the United States, you're responsible for them under two different laws. First of all, you sign an affidavit of support under federal law stating that you're going to support that person up to a certain time. And then under the state law, you're required to support your spouse if your spouse is incapable of supporting themselves. So for all those men who likes to marry women who are incapable of supporting themselves and are uneducated and may never be able to work a day in their lives, I would say good luck. But if you do encounter a problem, give me a call. You see my number there. It's 718-877-3100. Now, let's turn back again to the final issue as it regards to equitable distribution. Now, I've already told you how to keep your assets separate and distinct and not to commingle your assets. So if you came into the marriage with assets, learn how to keep those assets separate and do not commingle it with your marital asset. Now, in the divorce itself, and the court is going to assume that all the assets that the party has is considered marital assets. Now, I want you to bear in mind there is a presumption in divorce that all assets that the parties own is considered marital assets. Now, you can rebut that presumption. Any presumption can be rebutted, because if you feel like some of the assets that you now own, you owned it prior to the marriage, but you may have, it may have accumulated interest, or it may have appreciated, then you're going to have to rebut the presumption that your assets is marital assets to the court. Now, you got to ask, how do I rebut the presumption that my asset that I had before getting into this marriage is separate and distinct from marital asset? For instance, if you became entitled to inheritance, let's say a family member died and left assets for you, you inherited that, and you took that asset and you say, okay, let's say it's money. Let's say your grandpa died and he left you $500,000. And you said, okay, I'm going to take this $500,000 and I'm going to purchase an investment property, and then I'm going to put tenants in there to bring me an income every month. Now, that asset there, because it's an inheritance, it's not subject to equitable distribution in a marriage. So if you got an inheritance, make sure if you're divorcing your spouse, do not, under any circumstances, include that as part of the marital asset, because it's not. And even if that asset, let's say you got it during the marriage or before, it still maintains its distinctiveness So long as you do not invest any of your money, which you and your wife are bringing in and putting into your joint account, do not invest that into that property. Anytime you got an inheritance or otherwise, keep that asset separate and distinct, and do not commingle it under any circumstances whatsoever with your assets that you're earning, or income, whatever it is that you're earning jointly and bringing into your home with your wife. So inheritance distinct, pre-acquired asset distinct. Do not commingle and retain, and it will retain its separate and distinctiveness from the marriage. Another way is, if you, let's say for instance, you were married to somebody and then you guys divorce, and this is something that has happened, so don't think it's impossible. Let's say you're married to somebody and you guys divorce, and during the divorce there was assets, and you guys divided the assets, and you said, okay, you keep this portion of the asset and I will keep this. And you have to make sure that either in the divorce judgment, or if you decided that you're going to settle, so there's going to be a stipulation of settlement, you and your spouse make clear that the property that you settle in the first divorce, even if you decide to remarry, it's going to remain your separate and distinct property. So that if the parties then again decide, okay, we're going to remarry each other because we decided after this break, we decided that we're going to get back together, make sure that asset that you settled in the first divorce, you keep it separate, so that when your spouse comes back, they have no right to claim title or interest in that asset, because it maintained its distinctiveness by virtue of a first divorce. It was yours. And even if you decided that you're going to get back together, it's still going to maintain its distinctiveness as separate non-marital asset. And you do not ever intend to commingle it and to make it marital asset again. Now, if after the parties remarry, they still acquired more assets, new assets, then in that situation, they're going to come up with the different way, different methods as to what's going to happen with the new assets that they required. But again, like I said, you've already made the decision that you would like your previously acquired assets to maintain its separate and distinctiveness from any new asset that you would have acquired during the marriage. Now, I think I've touched on most of the assets that you could maintain its distinctiveness. And then anything else that was acquired by you and the spouse during the marriage, that's going to be considered marital. Now, there's another way to rebut the presumption, even if you purchase assets during the marriage. The other way to argue that it's part of non-marital asset, or a larger portion, it should be considered non-marital, is if the parties never commingle their finances or pool their resources during the marriage. And believe you me, there's plenty of marriages like that where the parties maintain their assets distinct and separate. So there's never any commingling. The husband works for his own money and keeps it to himself. The wife works for her own money and keeps it to herself. The parties do not have any joint accounts. And basically, all one spouse does is pay towards his rent, his or her rent. That spouse would have had to pay a rent. Either they stayed with you or they were somewhere else. That money would have gone to their rent and their food and their utilities either way. So you can use that argument, and it's written in numerous cases. Numerous cases, the party has argued in the state of New York, where there was no commingling of assets. The party never maintained a joint account, so there was no pooling of resources. And the parties just maintained separate and distinct lifestyles. They just went on their lives separately. Wife purchased her stuff differently and separately. Husband purchased his stuff different and separately. They might have owned assets jointly, but mainly one spouse contributed the most towards that asset. Then that's the way that's going to go. The court is going to award the bigger portion to the spouse who invested more into the asset. So, for instance, if the parties owned a house, they owned a property, right? And let's say the husband or the wife was putting 90% of the mortgage payment, whereas the other spouse was just putting 10%, or didn't even care how the household was being ran, then the party who put the 90% can rebut the presumption, weigh down, and make sure that they're awarded 90% of the value or the interest in the property. And the other spouse who did virtually nothing, make sure that that spouse is only awarded 10%, or in some instances, nothing. In one case I saw, which to me is a very egregious case, the judgment and everything seems very highly egregious. And I don't want to name the judge in the court of the state of New York on this live, but there's one case which I know about where the wife told the court that the husband at one point contributed a lot towards the property. And then at some point, the wife testified, and this is on a transcript. The wife testified that she was the one taking care of the household at one point, and the husband was using his money to spend it on other women outside of the home. And he wasn't taking care of his responsibilities in the home. And what the judge did, which by the way, I keep saying it's a really an egregious decision on the part of the judge awarded the wife 60% of everything, including the husband's retirement account. 60% of his retirement account, 60% of the value of the home that the wife claimed that the husband contributed at one point, but then she said he stopped contributing and it was her only that was pulling the weight of the family. The most egregious part of the judgment is, even though the judge himself read in his own decision that the wife said at some point she was taking care of the household single handedly, the judge awarded that wife maintenance, which, by the way, the attorney who was representing the husband also is very negligent and he should have been sued. Because if somebody is telling the court on the transcript in test during their live testimony that, hey, I was pulling the weight of the household. I was paying the mortgage because we had a tenant. I was taking care of the children. I was taking care of the bills, the utilities. Then it tells me one thing, that that spouse is self-supporting. So it doesn't seem very logical that any judge in his or her right mind would, if somebody's telling you that they're self-supporting, award that person, on the other hand, with maintenance. What the judge was supposed to do is award the equitable distribution, which he did. He gave her an entire 60% of even the man's retirement account, right? And then she should not have been entitled to maintenance, because at that point, you were already self-supporting because you already give testimony that you could have paid all these bills on your own, right? So it was kind of an inconsistent judgment, but that's one for the books, and people need to be familiar with this judgment so that you will make these crazy mistakes in your practice as attorneys. And the other worst thing that the judge did is that the parties had property in Guyana, and he didn't even apply the laws in the country of Guyana. And people who've been following me and watching my shows knows that I am very vocal about this, that every property located in any land, the country that the property is located in has sovereignty over that land. The laws of that land is sovereign, and any other country's laws it does not take precedent over the law of the sitters where the land is situated. So therefore, that judge responsibility was to apply the laws of the land as it relates to equitable distribution. And you know what's even more egregious is that the judge claimed that because he has jurisdiction over the parties, he exercised jurisdiction in persona, which I find to be very laughable, to exercise jurisdiction over the land in a foreign country, even though it's trite law that you cannot apply the laws of a foreign country to land situated somewhere else across the ocean. This is trite law, guys. So if you're in a situation like that, make sure you pick up the phone and give me a call and let's sort this out. Don't get caught up in a situation where you do a divorce trial and the judge apply the laws in that state that you're having the divorce. So if you're divorcing in New York or New Jersey and you have land in Guyana, ensure that the judge, your attorney, is aware of the laws in Guyana and how it applies to land in that country, and what is the presumption as it relates to marital land or property, real property in that country, in that foreign country. I think any country that falls under the British system, British common law, I think every judge who has any learned judge would know that you cannot apply the laws of a foreign country to land. When it comes to land, it's very different because of the principle of sovereignty. Okay. Now, I think I've dealt with all of the instances as it relates to marital assets and how the presumption operates, and how you can rebut the presumption by showing that there was never any commingling of assets, and by showing that, oh, each party maintained their property distinct. I think the only thing that people sometimes argue to get interest in other parties' property is that they provided emotional support to the spouse, because that's used as one of the things. But just remember, if it was always a volatile relationship and there was not, it wasn't a loving, caring relationship, you can rebut that also by claiming that, you know, you had a very volatile relationship. The parties never agreed in principle on anything, and they lived their life distinct and separate from each other. So, guys, I hope this was helpful for some of you who are thinking about how you're going to divide your assets during a contested divorce. And if you need help with that, you can see my number there. You can give us a call. The Washington Law Firm, the phone number is 718-877-3100. We're located on Utica Avenue, 455 Utica Avenue in Brooklyn, New York. We do offer free 50 minutes consultation. So if you believe that your life might be affected by anything that I've just said today on this live, please pick the phone up and give me a call. Give the office a call at 718-877-3100. Thank you so much, guys, for joining this or for viewing this video. For those of you who believe it has been helpful, please give it a like. Please press the like button and share it as much as you can. Share it as much as possible. Thank you so much for all your support. Thank you for those of us who have faithfully supported the Washington Law Firm. Thank you, and see you again next week, same time at 4 p.m. Bye, guys. Enjoy the rest of your weekend.